This is Twit.
What can you tell us about kind of the setup for this case and how this came to be?
Sure. So back in 2017, and so it's been a couple of years that we've been litigating this case, we filed the initial lawsuit in federal court in Boston. And we filed the lawsuit on behalf of 11 clients, or we call them plaintiffs. And all of them were U.S. citizens, except for one is a green card holder. And they all had their devices searched or seized at U.S. borders. So that includes the land borders, as well as international airports, where the first point of entry into the United States is an airport. And they, like I said, they all had their devices searched or seized, and they felt like this was a significant privacy invasion. So they had all reached out to us, or also ACLU, and we agreed that these policies and procedures of DHS and the border agencies, CBP and ICE, were outrageous, if not also unconstitutional under the Fourth Amendment. So we decided to sue.
Yeah, that's fantastic. Kind of joining this alliance of the EFF and the ACLU and your efforts. Obviously, that your efforts were a success. Like, as you kind of ventured down this path, like, were you hopeful, or did, I mean, sometimes I imagine you go into these things expecting that it's just bigger than what you can pull off, but I'm happy that you do it. Like, were you hopeful that you could actually affect change in this case?
We were hopeful, but what we do as nonprofit organizations that focus on civil liberties, we take cases that what we call them impact cases. So they might be uphill battles, but if we are successful, we will positively impact not just the rights of our clients, but the rights of everyone in the country. So that's how we viewed this case, that it was a bit of an uphill battle in terms of existing case law not being very supportive of privacy rights at the border. But we felt like the violation of privacy in people's devices was something unique and different and unprecedented. So there is longstanding case law that says very clearly that if border agents want to search a piece of luggage, so I'm sure many of your viewers have come back into the United States, they've had to go through customs. Well, during the customs process, border agents can search through luggage to see if you're bringing in anything unlawful, or otherwise called contraband. And they can do that without any suspicion of wrongdoing on your part at all. Like they can do completely random searches. They can do searches based on mere hunches. Or they could actually have, a lot of information that suggests that you might be transporting something illegal. But the point is that really they can do completely suspicionless searches of luggage. And so the agencies were trying to apply that same rule to devices. And we argue that that is just not appropriate under the Fourth Amendment, that Fourth Amendment analysis requires looking at the privacy interest in the thing that's being searched. And because devices can hold, hundreds of gigabytes, if not terabytes of data, and can reveal everything from, our most intimate correspondence to facts about us, like our health conditions, our financial status, our political views, et cetera, that searches of devices were just completely different than luggage.
And obviously the courts agreed in the end. And so I guess my question here is maybe a little from a suspicious front. Like sometimes when rulings happen like this, I'm like, okay, well, law is complicated. So sure, this particular ruling says this, and I want to believe that this will happen, but there's got to be some way around this. Like, people who are absolutely willing to make this happen. Maybe it's the pessimistic side of me that's like, okay, well, how else are they going to make this happen then to get around this? Do you envision that? Is this a pretty airtight kind of ruling as far as that's concerned, or do you envision any wiggle room?
That's a good question. Let me unpack what the ruling actually says, and then we can kind of like go from there. So, and bear with me, I want to unpack this for your viewers because
Sure.
we actually quite happy with the ruling. So she did say that wholly suspicionless searches of people's digital devices at the border are unconstitutional under the Fourth Amendment. But then the rule that she stated was that all device searches require reasonable suspicion that the device contains digital contraband. So what that rule means is a couple different things. So first is that totally suspicionless or random searches, or even searches based on hunches or even the biases of the border agents, are no longer constitutional, right? So that's huge. Then what she did is that she collapsed the distinction between manual and forensic searches. So that way, and this maybe goes a bit to your question, agents can't sort of can't get around a higher standard. So what do I mean by that? Existing CBP and ICE policies have required reasonable suspicion for forensic searches. So that's basically where they take your smartphone or your laptop, they plug in a separate forensic computer, with forensic software, and they can sort of more efficiently search through your hard drive. Their policies generally require reasonable suspicion to do that. The problem is that most searches of digital devices are manual, where they ask you for your password or ask you to unlock your device, and they just sort of tap through it, mouse through it, etc. And so by her requiring reasonable suspicion for both manual and forensic searches, there's no way for the agents to get around this higher standard by choosing a different method of search. So that was also a huge aspect, a hugely important aspect of her ruling. And then finally, the fact that she narrowed the scope or the purpose of device searches to only finding evidence of digital contraband, that's also hugely important, because what CBP and ICE have been doing is accessing people's data for a number of reasons. And one of those reasons is just to kind of see what people are up to, basically conduct fishing expeditions to see if maybe they can uncover some kind of evidence of wrongdoing. But we argue that that's completely untethered, sort of completely disconnected from the purpose of border searches in terms of border security. And she agreed with us. And so she said, because border searches, even of luggage, have traditionally been intended to interdict contraband, she applied that same limiting rule to the device searches. And so that's hugely important, because we've seen searches, involving text messages and emails and metadata like location information that clearly have nothing to do with interdicting contraband. And in this case, she had mentioned a couple examples. So child pornography, unfortunately, is a very common form of digital contraband, but possibly also copyrighted information, so unauthorized copies of digital media, maybe classified information, but that's going to be very rare situation. So that's the whole of the ruling. And overall, we think it's quite good.
That's a fantastic run through, very comprehensive. I appreciate that.